Hello everyone and welcome back to the channel. Hope you're all keeping well. And welcome to the latest episode of our series of videos looking at criminal law in England and Wales. Primarily we're looking at videos that will help people studying the law, and it's based on Blackstone's syllabus for criminal litigation, but hopefully it will give a better idea of various aspects of criminal law just for the general public also. Thank you for everyone who has subscribed so far. It does help to grow the channel. So if you do like the content, please do like and subscribe. And today we're looking at adverse inferences. In other words, the right to remain silent. And you may think that being in a police interview or at trial, the less you say, the less you can incriminate yourself. However, we're going to bit more deeply into that today and have a look at the law. And this is one of the most misunderstood concepts in criminal law: adverse inferences from silence. So under the Criminal Justice and Public Order Act 1994, specifically sections 34 to 38, juries can draw conclusions against a suspect or a defendant when they choose not to answer certain questions. So now let's clear up a common misconception straight away. Silence does not equal guilt, but silence can allow the court to draw conclusions if certain legal conditions are met. And adverse inferences, or a negative view from the jury, can arise in police interviews, failure to explain objects or marks, failure to explain presence at a place, or even failing to give evidence at trial. But these are highly regulated. Judges must give careful directions, and the jury must understand exactly what they are and what they're not allowed to infer from the silence. So in today's video, we'll unpack each type of adverse inference, when they apply, and crucially when they don't. So let's begin with section 34, and that's silence in a police interview. So just a side point here, silence is not necessarily just not answering the question. Sometimes you probably heard of a no comment interview, and some people don't answer any questions and simply just say no comment. Sometimes the solicitor advises this depending on the facts of the case, and sometimes if someone's not represented, they feel that's the best course of action if they don't want to incriminate themselves, for instance. But section 34 is probably the most important for both lawyers and the general public. It allows a jury to draw an inference when a suspect stays silent in interview, but later relies on any fact at trial, which they could reasonably have mentioned when first questioned. So for instance, if at trial, which in the case of the current climate, 2025, sometimes the trial is 3-4 years after the event, you need to make sure that the jury don't come to a conclusion that you've had 2 to 3 years to concoct a story or fabricate a story. So if you had the opportunity at the interview, which could have been on the next day or a few weeks after, to give a genuine reason why you were at the scene or why you had a mark on your body, then you should have given that. And to later rely on it in trial, there's definitely a possibility for adverse inferences there. So this is why the police say it may harm your defence if you do not mention when questioned something which you later rely on in court. And please do refer back to the chapter 2 video in our mini-series looking at PACE codes, Police and Criminal Evidence 1984, and the police caution that the police must give. And that wording is lifted straight from the law. But there are strict requirements. An inference can only be drawn if, 1, the suspect was cautioned properly, so that it may harm your defence if you do not mention, and 2, they had the opportunity to consult a solicitor, and 3, the fact omitted is something they genuinely could and should have mentioned at the time. The case of Argent, I'll put at the bottom of the slide there, is key here, emphasises that the suspect's personal circumstances do matter. And some of the factors to be considered are age, experience, mental health, shock or confusion. If there's a reasonable explanation for the silence, no inference can be drawn. So section 34 isn't a punishment for silence. It's a tool for evaluating whether silence was tactical And this is quite a nuanced, complex area of law that the judge needs to consider very carefully and to instruct the jury accordingly. So sections 36 and 37 of the Act deal with suspects who fail to explain physical evidence. And section 36 covers objects, substances or marks found on the suspect, for example, blood on your clothing, paint on the hands or scratches on the arms. Section 37 deals with suspects who fail to explain their presence at a place, perhaps being found near the scene of a burglary. But again, strict conditions apply. The suspect must be under arrest. The police must give a special warning, not just a caution, and the suspect must have the chance to speak to a solicitor. The suspect fails to account for something that obviously requires explanation. If those conditions are satisfied, a jury may draw an adverse inference, meaning they can consider silence as supporting evidence for guilt. But if the suspect was distressed, intoxicated, mentally unwell, or simply didn't understand the special warning, then the inference should not be drawn. And you do see police officers, they do ask if the defendant understands after giving the caution or the warning. So they must understand the caution. And these provisions are powerful, but only when used correctly, carefully, and proportionately. So what about trial then? So section 35 deals with defendants who remain silent at trial. That is, choosing not to give evidence in their own defence. Now, importantly, a defendant has an absolute right not to testify. The law protects that right. And where a defendant chooses not to give evidence, the jury may draw an inference that they have no innocent explanation to offer. This only applies if the prosecution has established a case to answer. And please refer back to the episode on Inside a Criminal Trial, my early videos, to look at the no case to answer application, the half-time submission, as it's called. And for the case to proceed to the defendant being on the stand, the judge has deemed that there is a case to answer. So the defendant is fit to testify, and they have been warned that the court may draw an inference. So these all apply within section 35. The inference cannot be the sole basis of conviction, though, but it can strengthen the prosecution case when combined with other evidence. Judges must give a precise direction, sometimes called a Christie direction, explaining the purpose and limits of this inference. So the law tries to strike a balance between protecting a defendant's right to silence and allowing the jury to evaluate the significance of silence when an explanation is expected. So this slide here is vital, especially for bar course students. So there are many situations where adverse inferences are prohibited. And let's go through the key ones. So no access to legal advice. If a suspect was denied a solicitor or the delay was unreasonable, no inference can be drawn, and that silence in that situation is protected. If silence arises from shock, trauma, learning difficulties, or vulnerability, again, no inference. And youths and vulnerable adults alike, courts must treat them with exceptional caution. Often police must have an appropriate adult present. Otherwise, inferences are unsafe. And also the facts were genuinely unknown at the time. So if the suspect could have mentioned something because they didn't know about it, then section 34 cannot apply. Remember, adverse inferences only apply where silence is genuinely suspicious, not where silence is understandable. So let's bring everything together then. So here's the big picture. Silence does not equal guilt, but silence can create problems when an innocent explanation should have been given earlier. Inferences must always be fair and carefully controlled by the judge, and the judge must give detailed directions. And the defense must be ready to explain the silence when appropriate. And here's the key takeaway for anyone who is watching, and if you are unfortunate to be involved in a criminal case, whether you're a law student or a member of the public, Always ask for legal advice before a police interview. It's your right, it protects you, and it ensures the interview is fair. That was just a very brief breakdown on the right to remain silent and adverse inferences within criminal law in England and Wales. Hopefully you found that useful, insightful, and if you do have any questions on this video in particular, do drop them in the comments below. I try to answer all of them. If you do have any personal requests for me to cover an area of law, also drop them in the comments below. But I do thank all of the viewers for watching. If you did find it helpful, please do subscribe just to help grow the channel. But hopefully see you on the next video, and take care for now. Bye bye.